There are basically three phases of a personal injury case. There's the medical treatment and investigation phase. There's the attempt to settle the case with the insurance company phase. And then there's the litigation phase. Early on in the case, right after you're injured, there's a period of time in which you're getting medical treatment and I'm investigating your case. We can't move forward and try to settle your case until we know the full extent of your injuries and damages. During that stage of the case, you need to go through your medical treatment to make sure that you're properly treated for your injuries. And on my end, I'll be investigating the case and putting all the responsible people on notice of the claim so that they can notify their insurance companies. After your medical condition stabilizes and we know the full extent of your injuries and damages, then we can try to settle the case with the insurance company if that's possible. What we do is gather all of your medical records and determine the impact of the accident on your life and your activities. We may hire expert witnesses to prove your damages. And we put all that information together into a settlement demand package to send to the insurance company. Then we try, if we can, through negotiation, to settle the case with the insurance company without going to court. If we're able to settle the case with your insurance company without going to court, that's beneficial to you because you avoid the stress and time involved with litigation, and you also avoid the expense of litigation, which reduces your ultimate recovery. If we're able to settle the case with the insurance company, then you'll be paid your settlement and you'll sign a release giving up your claims against the defendant, and that'll be the end of the case. If we're not able to reach a settlement with the insurance company, then we move forward with litigation. We file a lawsuit against the defendant and we proceed through the litigation process. The litigation process involves three phases: pleadings, discovery, and trial. During the pleading stage, we prepare a complaint that sets forth our claims against the defendant, and we file that in court, and then the defendant has to hire a lawyer through the insurance company and answer the complaint. During the discovery phase, each side gets to find out about the other side's case, and this is done through a number of procedures. It's done through written questions that are served on each other. It's done through depositions, whereby the parties and the witnesses have to testify under oath about the facts of the case. It's also done through disclosure of expert witnesses. In a personal injury case, the injured party can also be compelled to attend a defense medical exam, which is an exam with a doctor who's hired by the defense in order to evaluate your injuries. At the end of the discovery phase, it's common that the insurance company will reevaluate the case because now they have a bunch of information that they didn't have before. So it's possible that a case will settle after discovery but before trial. The final phase of litigation is a trial. That's the in-court proceedings in which we prove your claim and the defendant defends against the claim. It involves opening statements, testimony of witnesses, cross-examination, exhibits, closing arguments, and ultimately a jury reaching a verdict. Trials are, of course, very risky for both sides. In a trial, somebody's going to win and somebody's going to lose. What we try to do in our practice is settle cases if we can. If we can get a reasonable settlement for our client, then it makes sense to settle the case rather than run the risk of what might happen at trial. However, if we can't settle the case for our client through negotiation and settlement, we don't hesitate to go to trial and take a case all the way to a jury verdict. If you have any other questions about the three phases of a personal injury case, please don't hesitate to contact me.